A very good morning to our esteemed guests, all learners, and everyone present here virtually. I, Alvin DeCosta, on behalf of Symbiosis School for Online and Digital Learning, would like to extend a warm welcome to each one of you present here virtually for this session on the evolving intellectual property landscape. It is our immense pleasure to welcome our guest today, Advocate Omkar Nitin Ghate. Sir brings over more than 8 years of hands-on experience with an expertise spread over fields relating to intellectual property, such as trademark, copyrights, and designs. He has extensively worked on filing trademark, copyright, and designs applications in India and overseas, handling matters of objections from trademark, registry, and third-party opposition on usage of trademark, attending hearing with trademark registry, domain name dispute cases with WIPO, cease and desist notices of trademark and copyright, conducting due diligence of profile and brand management and IP audit. Sir is a member of Bar Council of Maharashtra and Goa. On behalf of SSODL, I once again warmly welcome you, sir, and request you to take over the session. Over to you, sir.
Thank you. Thank you, Alvin sir. Thank you. It's my pleasure to be there on this session, and I sincerely thank Symbiosis for this opportunity. And good morning, everyone. I hope it is Sunday morning, and it should not be like a dull moment for all of you. That given that it is a Sunday, right? So, thank you all for joining this session. So, right away what we'll do is I'll just share the screen. uh just let me know once everyone is able to see the screen.
Yes, sir.
We are able to see the screen, sir.
Yeah, there it is. So like I said, so first of all, I'll just quickly brief myself. So I have been associated with Legalogic for more than 8 years, and I have been handling the matters of IPR that includes trademarks, copyrights, and design. So, and again, so that is not with regard to India, but overseas as well. So, thank you again. The most important part that why we are here, right? So, in all our day-to-day life, we see n number of things, and we know that this any part of this working that we do in terms of whatever we see, whatever we use, it something that has come out of a human intellect, right? So this is just to have an understanding about what exactly the IPR is. Okay, so and how the IPR is governed in India, and how you get benefited out of this particular and most important aspect of our day-to-day living. So the whole thing and the whole idea is to have a understanding about what types of IPR is there and how you get benefits out of it. So I'll just quickly start. The most important part is before we do or before we see anything, we being a IP firm, we would like to disclaim and say that whatever the images or whatever the pictures that has been used in this session, those belongs to the respective person, and we don't claim any sort of trademarks or copyright belongs to each one of them, right? So the coming to the most important aspect, basics and concepts of various types of IPR. So like I said, so on our day to day basis, we use number of things, right? So currently what we are doing is we are conducting a session on this particular platform Zoom, or we are delivering this session through the use of the laptop, the computer system, so on and so forth. So we all know that this has come to our day to day's life, but whether we have thought how this particular aspect has governed, right? So there are number of aspects that are involved in creating those small things, right? But we need to make sure that all these come out of a human intellect. So this is nothing but a creation of the human mind. So when we talk about intellectual property is nothing but a creation of a mind, right? So it is not something like that that has come to our knowledge just from the nature, or automatically things had happened, right? No, that is not the case. Intellectual property is nothing but a creation of human intellect. Whatever, let's say, the moment we create anything in terms of whatever, in terms of writing, in terms of thinking, or whatever, the taking pictures, drawings, anything, that is nothing but an intellectual property. Correct? So, as stated here, intellectual property means anything new, innovative, or anything that has come to the mind of a human, and that has been expressed. It is nothing but a intellectual property. Now, there are n number of aspects now coming to the intellectual property. Now there are, like mentioned here, there are few important aspects that we come to day life, such as invention, right? Invention means nothing but a creation of new thing that are not there in the market, or that have not been created till date. Now that particular aspect falls under patent. Okay. Now when we talk about artistic work or literary work, that falls under copyright. It is nothing but a uh, sorry, someone has raised the hand. So is there any question? So I just seen someone on the participants thing. Shall I continue, or is there any
Sir, you can take these questions later on. You can continue right now.
sure. So like I said, so first thing is about patent. Now coming to the other aspect, which is copyright. Copyright is nothing but a artistic work or literary work, or anything that has been created and it is implemented in terms of the work that we do. That is nothing but a copyright. Now coming to the third thing is about, we all know trademark. We have all time listen to the brand name, the slogans, all these things, the logos. Those are the important criteria that falls under the trademark. There are two or three more aspects to this particular thing. One is GI, which is nothing but a graphical geographical indication, and fifth one is Plants and Varieties Act. So these GI means, geographical identification is nothing but a identifying the goods or the products from the origin of that particular aspect. So I'll touch base upon those criteria as well. Now coming to the detailing about what is copyright. So we all know that copyright is a right which is created from the minds of a people, and it is nothing but a let's say, let's take an example. Okay, so the moment I click picture from my mobile or whatever, the moment I uh, write something in the flow chart or whatever, the moment I create that work, it is the copyright. Okay, so there are n number of things that are covered under copyright. So just to give you an brief about what exactly the copyright, it is nothing but a bundle of rights to reproduce the work. In a common language or in common parlance, copyright is nothing but a right to copy. Okay, that does not mean that you are allowed to copy someone else. So it is nothing but a right to copy of or on your own work. Let's say I have created something, or I have a book. Okay, I have written a book. So that particular, under this particular copyright, this will give me a right to copy and allow any other third person to have the copies of that work. So it is plain and simple, nothing but a copy, or giving a right to about the copy and a reproduction of the work. It is as simple as that. To brief you in terms or in detail, there are things that are, many aspects that are covered under copyright. So if you see, first thing, it is literary work. Okay, literary work means a book or anything that you have written, a poem or anything in a written form. Okay, that is called as a literary work. Now, we all know that you guys are into digital era, and many of you use are into the computer software and all those things. So not only in terms of literary work, not only the books or such material gets protected, but the source code. Okay, the any person who develop a computer source code, any person who develop a website interface, okay, graphical user interface, those are also covered under the copyright. Now when we talk about particularly about source code, source code is one aspect that will definitely get covered under a literary work, and you can always have the protection for that particular code that you have developed. Okay, that is part, that is one aspect of a copyright. Now second aspect is artistic work. Okay, artistic work is nothing but a, suppose anyone created or let's say someone is an artist and he's just draw the painting, it may be in the form of a I mean portrait, or any form of paintings or anything that is considered as artistic, those gets covered under an artistic work, like I said. So the moment I take a picture, okay, so the moment I pick or a photograph, that will also fall under the copyright thing. Okay, this will certainly give me an right to claim ownership on that photograph which I have just clicked. So those are also considered as an artistic work. Now the third aspect to the copyright is a recording, sound recording. Okay, there are again two aspects of recording purpose. The persons whose voice is getting recorded does have the same or equal right over his voice that is being recorded. Okay, that is also an important aspect that we always need to concern. Even if let's say someone's voice is getting recorded without his or her knowledge, there is, that is called as an infringement. Okay, now let's take an example. The currently, if I'm not aware that this being as I mean definitely I'm aware that this session is getting recorded, but if without my knowledge this particular session is getting recorded, it is nothing but a copyright infringement. It is copyright infringement of my work, the my voice, my presentation. So this is how the recording and all those stuff work under copyright. Other aspect is musical work. Okay, musical work is also one of the most important aspect in the copyright. So we have seen n number of cases in India where the music composers or the production houses or the producers of the film getting let's say legal notices over copy of their notations that are being used in the songs. So under musical work, the most important aspect is notations. So the notations, I mean it is graphically presented here. So the notations which are created for creation of this particular music, those are getting covered, and those gets covered under the copyright for the musical work. So this is also a very important aspect in India. So we have seen, I mean, there is a currently case that is going on with A.R. Rahman itself, right? So it has been alleged that A.R. Rahman has used a very, very famous and very long old jingle that has been used for the folk or the regional people. So under this particular aspect, you are not allowed to use such musical, even if those are in the public domain, and it is not there with particular aspect. You cannot use the musical work or any sort of work that is already there. Now coming to the other aspect, which is nothing but a, you we all see theater, right? So it is cinematographic work. So when any particular play, or let's say yeah, in terms of play or any live concerts are there, there are also some sort of copyright that is getting covered. So let's take an example of the person who are choreographing the overall structure of this particular play or the live concert. So that is the one aspect. So the choreographer, the person who is recording overall the play or let's say the live concert, that is second aspect of a copyright. Third thing is the artist. The most important part is the artist who are performing their work on the live thing, that is also a copyright. Okay, so those belongs to the each and every person. So but generally what happens in India or over all over the world, if any sort of play is getting recorded, or let's say any form of live performance are there, there is an arrangement between the performers or the artist and with the producer, saying that the artist allowing the other parties, means the producers or the organizers of that particular play, just to have the recording, and they have the right to reproduce or launch that particular recording that they have. If they don't, if there is no such agreement between these two parties, then and the other party, let's say the production or the organizers, without the knowledge of the artist publish that work, that is nothing but a infringement. So I trust, so these are the most important aspects of the copyright. So like I said, so you guys being into digital era and digital learning, so you definitely need to have an understanding and most importantly awareness about the creation of your work. So like I said, so computer software, graphical user interface, and we have seen many cases where gaming industry has seen a lot of copyright infringement, right? So there are number of examples. If you just go through the online thing, you will find that there are many large companies. So we all know that FIFA and everything, right? So I'll give you an example. So usage of let's say Messi or Ronaldo, okay, the name, the character, or the facial recognition of these people is also a copyright work. So you cannot use their facial expressions. Again, the most important part is we all know that the way Ronaldo celebrates his goal, right? So we have seen the same in the FIFA and all those gaming industry. So those you cannot use without the knowledge of the respective person. So that is the importance of the particular aspect that we called as a copyright. So we have seen what is covered under copyright. So there are certain other few criterias which is not copyrightable. Okay. Now when we talk about what is not covered, first thing is mere idea. Okay. Idea per se cannot be protected under copyright. The reason is copyright under, I mean under copyright you need to have something in feasible form, right? So let's say I have just an idea ki ye karenge wo karenge, or that will be taken care. This is not going to protected under copyright. That is going to get protected under patent. So mere idea will not be suffice to have a protection for copyright. Similarly, the names and titles. Okay, just I mean, let's say in the word Apple. Okay, we all use iPhone and Apples and Samsung, so on and so forth. So the names, the Samsung or the titles, those are not protected under copyright. Those are protected under trademarks. Okay, that is one thing. Second thing is just fact, right? So anything, I mean. Um, 1 plus 1 is 2. It's just a fact. So you cannot have an exclusive right on those facts, and you cannot claim copyright under this particular aspect. And fourth thing is originality. Okay, so if the work that you have created is not original, it will not fall under a copyright, or let's say you will not be able to claim exclusivity on this particular aspect that we call as a copyright. Okay, now in overall considering all those aspects, so just to brief and just to have a complete idea about copyright is nothing but a right to reproduce the work. And one more important aspect that we need to consider here is copyright is an inherent right. Means copyright is not mandatory to have the registration for the copyright, but it is good to have thing. Okay, like I said, so the moment you create the work, You don't need to go to the trademark or let's say copyright registry and say that, and let's say file an application. No, that is not the case. But the like I said, so the moment you create the work, the moment you take pictures, the moment you perform, it is it is or your own copyright. So that's it, it is plain simple. So this is about copyright. Now we'll go to the most underrated, I would say, underrated copyright, or let's say the IP protection in India. It is designs. Okay. Now we all have seen. I'll give an example. So we all seen in a day-to-day life the Bisleri bottle, right? So the shape of the bottle is unique. So without the label of the bottle, if I have that bottle in my hand, I will get to know that this is a Bisleri bottle. Without the label, I'll have an understanding this is Kinley bottle. Okay, it is as simple as that. So the meaning of the design is, I think, it is nothing but a protection granted to the aesthetics of the product. Okay, so the few features of the Designs Act is, it is the shape, right? So like I said, so the shape of the product, so it is all about the way it has been produced or it has been manufactured. The next thing is configuration, the patterns, the compositions of lines or combinations. So like, I mean, the important aspect about the design protection or design act, it is all about the aesthetics of the product. So this is I'll give you an example. So in the next slide, so you will have a complete idea about what exactly this particular um, IP protection will give you. Okay. uh, so so if we all know that this is the brand, we many of you use the brand, the Crocs, right? So the footwear, these people are very well known in the footwear industry. So and we have seen many, or let's say n number of infringers in terms of this particular Crocs. Okay, so the uniqueness about their product is the shape, right? So we all know, so like I said, so the without the label of the product, I get to know about what product it is. So this is the importance of the design. So if you have the unique configuration or unique structure to your product, you can go for a designs protection, right? So these are some of the examples of designs thing. Now what are the prerequisites of design? So again, the most important part is it should be new and original. So like I said, so it should not be in the let's say I have a bottle, or let's say the Crocs, I mean, what the example I've gave you. So it should not make an I mean difference that I have just tweaked the only one part of that product and I'm coming with her saying that this is my new product or this is what I have created. No, that is not the case. You need to have a very new and original product. That product should have a very, very uniqueness in terms of the shape, in terms of the aesthetics of the product. Now, coming to the other aspect, which is it says that it must not be disclosed to the public in anywhere in India or abroad. Means, let's say if I would like to have a protection for my product, which I believe that it is novel, or I believe that I have created that shape, but it is already, if that product is already in domain, or let's say if I have already started selling that product, then in that case you cannot go for a design protection, given that that particular design is already in the public domain. So this is the most important criteria for design thing. So the same will not work with copyright. So if any, I mean, the work you have created, if that work is already in the public domain, there is no such restriction on claiming ownership on the copyrighted work. So it is opposite to the copyright and trademarks. So, and the third part is must be significantly distinguishable from known designs or combination of known designs. So, and just to give an example, right? So there are number of mobiles that we use, correct? So if I have iPhone in my hand, and secondly, on the other hand, if I have a Oppo, or let's say a Samsung on the other hand, I will be in a position just by the look and feel of the product, I'll be able to differentiate between these two products. So that is the most important criteria, that the person or the third person should be able to distinguish between these two products, that one is the shape of the other product is different than the shape of the first product. So that is the relevance of the design. So we all know that there has been a landmark case between Samsung and Apple, right? So there has been a long debate that has gone in the US for the design and patent aspect, the long fought battle between these two giants. So this is all about their designs and aesthetics of the product. And the other aspect, which is nothing but a must not contain the scandalous or obscene matter. So those are very obvious thing that we need to consider for in terms of designs. Now the other aspect is advantages of design registration. So like I said, so in not just about copyright, in any form of a intellectual property, it is not mandatory. It is, frankly, it is not good for the society. Okay, not good for the inventors or creators, that basically IPR is a not mandatory aspect. So even if I am creator of the work, even if I am the originator of any product, I can continue usage without registering the particular work or particular design, unless and until it is not infringing any other's work. So that is the most important aspect. Now when we talk about advantages of registration, okay, the most important and very very important area of all this IP is whether you have a registration or not. Okay. Now, if I have a registration for my particular design, or let's say the aesthetics, and by the way, one more aspect, it is not about design that is already been created for the product. You can always go for the drawing that you have created, and you can submit with the photograph of that particular drawing with the respective registry with the designs act. Now coming back to the registration part, so registration will definitely give you an importance when you have a registration certificate, right? So now let's assume that if you have created, or you have product which is already in the public domain, and you believe that you are the creator of that particular design or that product, and you have been using that product for, let's say, last 10 or 15 years, someone comes up with the same design, okay, with the same design, with, let's say, 1 year down the line, or let's say in 2020 they started using or creating that product. Now in that case, given the fact that you don't have the registration of your product, you may lose a upper hand in terms of the ownership, claiming ownership, right? So it is the most important part. When you have a registration document or registration certificate, it will be a legal document to have the ownership of your own creation, or you are the creator of that particular design or that work that has been developed, right? So like it is mentioned here, so it increases the market potential. So whenever we see n number of our clients where there has a, when there is a investment strategy going with those particular clients, the investors always go for whether you have a registration or not. If you don't have a registration, the investors will always go and ask you that go and have a registration for your product. So, and compared to, whereas if you have a registration certificates in place, it will definitely increases the value of your product. So that is important aspect. Second aspect is safeguarding the features of the product. So like I mentioned, so a registration certificate will have all the details about your product. So why you have applied for this particular design, the shape, the aesthetics, all the minute details will get covered in the design registration certificate. So no one can copy the design that you have spent n number of time and money to develop that product. So when you have that registration certificate, you get that particular right. So exclusivity means it is nothing but a right to use that particular, or let's say claim any exclusivity over that particular design. So when you have a registration, you can claim all the exclusivity in terms of the design of the product. Encourage fair and competitive trade practices and promotes creativity. So like it is nothing but a creation. So it is as simple as that ki it is part of the IPR. It is nothing but a creation of the mind. Okay, so this is all about advantages of having a registration of design. Now coming to the other most important aspect, it is about trademark. So we all know that trademark is getting more and more importance in India. So we see hundreds and thousands of cases on a daily basis. We see names, logos, taglines, n number of things, and we all see TM as a nomenclature, R as a nomenclature, along with the words, logos, so and so forth, right? So those are nothing but a trademark. So simply, just to simply put, what trademark is nothing but a name or a logo which differentiates you from the other people in terms of the goods that you have provided, right? So it is nothing but a name or the logo under which you are allowed to sell your goods or sell your services, right? So it is like mentioned here, so it should be capable of being represented graphically. So when you see these two examples, right, so these two are giants, right? So uh, if you see Google, you will definitely come to know that what Google is into. If you see Amazon, you will definitely come into the picture what Amazon does. So this is the importance of the brand, or this is the importance of the name or the logo. Now many of you may don't know that if you see that uh, the arrow which is written from A to Z, right? There are number of aspects or number of thought behind this particular arrow. It shows there are two aspects. One is, if you go to Amazon, you will find A to Z things, right? You will not go anywhere, or you don't need to go to a grocery shop. You can find all the material like A to Z form. It also shows that a smiley face. Okay, so these are the importance of the graphical representation of your trademark or graphical representation of your goods and services, how you sell your services. Again, the third thing is, it may include visual symbols, words, signatures, which is more important aspect, name, device, label, numericals, or combinations of color, shape of goods and their packaging. I'll come to the next slide. You will have a better understanding. Now, I mean, we have seen this particular aspect, right? So, if you can just go through about this particular slide, so you will find n number of intellectual rights only in this particular bottle. Okay. Now, if I take the example of this Coca-Cola bottle, there are n number of things. We all know that trade secret is one of the important aspect of intellectual property, but unfortunately that is not there in India. There is no such governing law for the trade secret. But Coca-Cola being one of the highest, let's say, the company which spend highest number of money on just to protect their trade secret. So as of now, there is no one in this apart from the Coca-Cola itself. No one knows about the trade secrets or ingredients of the Coca-Cola, right? So that is their um, how these guys have created their wealth and brand. Okay, now when you see the Coca-Cola bottle, you will also find the other aspect which we talked about the designs. Okay, so the moment you take that bottle in your hand, you will feel that yes, this is a Coca-Cola bottle. If you have the Pepsi bottle, you get to know that this is a Pepsi bottle. So this is the importance of creation of your intellectual property. Now, when you see that Coca-Cola written, so there are number of aspects, right? One is the name Coca-Cola. It is as simple as that, Coca-Cola, Coca-Cola. That's it. So the name itself is a brand. Name itself in our trademark thing, we call it as a word mark. Word mark is nothing but a plain wording. under which you provide services. There is other aspect to that particular thing. The way Coca-Cola has been written, that is also the creation of the particular intellect, right? So the way it has been written, you can definitely go for a logo mark. Now if you see uh, the the signature of all, we know that, or let's say the logo, we all know it is about a Nike, right? So see, this is nothing but a very generic symbol, but the way they have created, the way they market their services, and the most importantly, even though I'll take the genericness and what type of trademark is there, in terms of, even though the trademark is generic, but the services that you provide under your particular trademark, that makes a lot of impact, right? So we all know Apple, correct? Apple is a technology company, but they know that Apple is a very generic term. It is a extremely descriptive and generic term. Now, if you come up and start selling fruits and under the brand name of a Apple, that will fall under a generic trademark. So you cannot claim any exclusivity right on the words which are generic or descriptive in nature. Means uh, you are able to describe the services that you provide under your particular trademark. Okay, I'll touch base upon that particular aspect. Now, with regard to the other thing, which is symbol, right? Symbol means nothing but a logo mark. Okay, that includes, again, the we all know that the symbol is of a McDonald's, right? This is nothing but, if you put this symbol on your let's say on any restaurant business, you will definitely, within 8 days, you will definitely get a notice saying that, boss, you cannot use the symbol as it describes the services that we offer, right? So this is the importance of a logo mark. So logo mark will also, in I mean, the importance or relevance of a logo mark means it includes designs, it includes graphical aesthetics of graphical representation of any work. So those are getting covered under a logo mark. Now there is other aspect which is called as a slogan, or what we call as a tagline. Okay, I'm loving it. So I'm loving it is their tagline. So under which, so they market their provide they market their goods and services. The other aspect about all this trademark is you can have a composite application for all this, which means you can go for a composite application which includes the logo along with the tagline. That is called as a composite trademark, where you will have all the aspects of your trademark. So if you see the Nike logo, we all know that just do it, correct? Just do it, there is their tagline. So if you see anywhere with regard to the footwear, or let's say clothing, just do it, you will get to know that this is a Nike place. There is a chance that they may market such product in this manner. So this is the importance, and this is the importance of registration for a tagline as well. There is other part that is called as a color trademark. Okay, in India, again, unfortunately, there are very less examples. So if you can see that particular example of idea. Okay, now if you remove that word idea from that particular square, and if you check yellow with regard to the telecommunication, okay, you will automatically get to know that this is with regard to idea, which means the the importance of the color trademark is the the gain which you have already have in terms of the services that you provide. Okay, now if you have orange color, okay, we if you all remember, there was a company called Orange that has got merged everything. But if you see the only the color orange in terms of telecommunication, you will get to know about, yes, this is with regard to telecommunication. So this is how it works, and this is the relevance of the color combination. Trademark is not limited to this particular aspect, right? So there are few more and extremely important aspect that is called as a, there are two more things. One is sound mark, and second thing is a smell mark. Okay, we all know that everyone used to watch Tom and Jerry, correct? So MGM is the production house. So the moment MGM used to appear on the screen, there was a sound of, or let's say, roar of a lion. Okay, that particular roar has been trademarked by MGM. MGM has the right to have that particular uh, trademark over that sound, or let's say roar of those particular lions. So this is the importance. So you can definitely go for a sound mark that is there. We all know that Intel, correct? Intel has one different type of that music, which is also a trademark, which is also their sound mark. So this is the importance. Other aspect is a scent, or let's say in Paris, I mean, definitely, particularly, it has gained popularity in Paris and European countries, that you can have protection for the smell of your perfume or dew. So can you beat that? So we are just stick to name, logos, and all those stuff. But whereas these companies, let's say Louis Vuitton or many big brands, they have registered the smell of their perfume. No one in this world can copy their smell, right? This is the importance. And you can definitely, I mean, there are some provisions with regard to sound mark in India, but I'm not sure how. As of now, we have not seen such thing in India, particularly when we talk about smell mark. So these are some of the important aspect, or these are the some of the most important examples how you can protect your trademarks in India. Other aspect is surname. Okay, surnames or signatures, these are also very important in terms of copyright. So we all know Kirloskar, we all know Tata, right? So these are the surnames. But what they have done is, over their surname, they have built a brand. They have built the empire with regard to their surname. And when you have such popularity in terms of your surname or in terms of your name, so on and so forth, you can definitely go for the trademark application, where you just need to provide uh, documentary evidences, or the or about popularity that you have, right? So we all know Mr. Amitabh Bachchan, Mr. Sachin Tendulkar, right? So what they have done is, also Shah Rukh Khan, so what they have done is, they have trademarked their names, their surnames, along with their signature. So no one can copy the signature or their name. And I mean, they cannot go in the public and say that under this particular name or under this particular signature we can start their business. So they will definitely have a legal notice from the respective owner, or let's say from Amitabh Bachchan, and so on and so forth. So I mean, the intention of this is, it is not just about coin the word or using the word. You can definitely have a protection for the surnames or the names, or even signatures. But you need to have the popularity in terms of the services that you provide. So this is the important aspect about, like I mentioned, about the surnames and signatures. So prerequisites. So uh, the most important area where we think about the trademark is, the trademark should not be a descriptive, like I stated. So let's say if I would like to sell vegetables and fruits, but I'm thinking of selling that particular fruits and vegetables under the name of apple. No, I cannot do that. The reason is, it is a descriptive trademark, means it describes the services. Now let's take an example. We all know Infosys, correct? Infosys, in my opinion, it is nothing but a coined word of two words. One is information, and second thing is system. What they have done is, they have combined these two words and coined it and saying that Infosys. Now, if you go and file a trademark application which includes information and technology, okay, the trademark registry will right away reject the application, saying that you cannot um, file a trademark application which includes the word information technology, or let's say which has or which describes the services that you are providing. It is nothing but a descriptiveness. So you cannot go for descriptive trademarks. Must not be generic. Generic words are very barred from the trademark application. Any generic word is barred, like information or technology, so on and so forth. So grocery stores, right? So those are very generic terms. It must not deceive the public or cause confusion. So, like I stated, so if I come up with the name Nike, okay, and I start selling, uh, let's say, or let's say I've started restaurant business under Nike, okay, it is going to cause confusion in the mind of people. Boss, ki, we all know that Nike is a clothing brand, or let's say, uh, footwear brand, whether they have come up with such a restaurant business. So if that is the case, it is going to confuse the people. You cannot know, or you cannot go for such trademark application, which is going to cause confusion. Again, the other aspects which are common in all the IPR things is, it should not hurt the uh, religious sentiments of the people, or it should not have scandalous or obscene matter. And again, the most importantly, you cannot go for a national emblems, or national, or let's say the names of nations, or the emblems that are used in India or anywhere in world. So I cannot go for a trademark application for a logo which includes our flag, or which includes the name India or such other things. So if you have such other aspects in your trademark, you will not be allowed to use the trademark. So those are barred from trademark perspective. So this is we all have seen these symbols along with our the names of, and the logos, right? So service mark, I mean, generally it is a US practice that these guys what use is trademark. I mean, see, I have missed on one part, which is about a trademark classes. Okay, trademark is a class specific protection. Okay, there are 45 classes which are governed under the trademark, which is 1 to 34 talks about goods related aspect, whereas 35 to 45 talks about services related aspect. Now let's say if I'm into manufacturing of hardware, or manufacturing of any sort of clothing or such product, I fall under the classes which are 1 to 34. Now let's take an example. Okay, if I'm into computer software as a product, okay, I have created a product which is a software, but that is considered as a product, that will fall under class 9. But if I am a service provider in terms of information technology, it may include SaaS, PaaS, cloud based technology, but I am a service provider, that will fall under class 42. So now again, let's take an example of, if I run a restaurant business, okay, that will fall under class 41 or 42, or again 43 is very limited to restaurant business. But if I manufacture packaged foods, if I manufacture milk product, I will fall under goods related classes 29, 30. Those are the classes which talks about food product. So that is the relevance of the trademark. Now coming back to these symbols, okay. So SM means nothing but a service mark, so which provide the services with regard to the trademark that we provide. But in, like I said, so in India mostly these two symbols are used, that we call as a nomenclatures. Okay, when a trademark is filed, okay, and it is under a process of registration, you can use TM as a nomenclature, which denotes that the particular trademark is under process and it is yet to be registered. One more aspect on this particular nomenclature is, even though the trademark is objected, opposed, or is in process of registration, you can use TM as a nomenclature. No one is going to stop you from using that nomenclature. The moment the mark, the trademark gets registered, you can use that R symbol. We have, I mean, we all have seen those symbols, right? So whenever you see R as a nomenclature along with your trademark, this means that this particular trademark is a registered trademark. Okay, so those are the basic things about trademark and classes, about how to use the trademark, or what types of trademarks are available in the uh, available to you. Now coming to the other aspect which we know as a patent. Okay, we have seen many people saying that, boss, this is my patented property, boss, this is what I have patented, so on and so forth. Patent means, see, we all know, like we stated earlier, patent is nothing but a creation or innovation that is not already in the public domain. Okay, anything, it may be in the form of a product, or it may be in the form of a process which is novel and which is innovative anywhere in the world, then you can go or think of going for a patent. The other aspect is it should involve an inventive steps. Now, when we say about inventive step, whether does that mean if I need to go to north where already product is working in the south direction? Yes. So if you know that outcome of that product is going to be the same, but if you have created the steps that is going to create the output in a completely different manner, which we call as the inventive steps, then you can always think of a patent. Again, the third aspect is capable of industrial application. Capable of industrial application means it should be usable to the industry at large. It should not happen that only idea is there and you have filed a patent application. You should use that application or product to the industry. Unless and until there is no such aspect, you cannot go for, or it will not fall under the patent related aspect. Novel. Novel means, I mean, in the next step, I have included these two aspects, novel and non-obvious. So the reason of this particular five pointers is nothing but, when you think of going for a patent application, you need to think through these five aspects. Okay, if you does not fall under any of those criteria, you may lose the patentability. Now, when I mean, we generally suggest our client, whenever if you decide to go for a patent, you definitely have a patent search. Okay, and this is also applicable to the trademarks. Okay, now when we talk about conducting a search with regard to trademarks as well as patent, we have, the moment we conduct the search, we get to know about what are the possibilities of having the trademark or patent in place. Okay, when we have a trademark search in place, we will definitely have an understanding. Let's say there may be a chance from the trademark registry that this is going to get objected, or we may have a feeling that any third party may file an opposition, or also we find out that no, there is no other trademark is there, we can file an application. That is the most important point we need to consider before we file any such applications, right? So this is also applicable to the patent aspect. Like I stated, so novel. What is novel? Novel is nothing but no other technologies anywhere in the world should exactly similar to your invention. Plain and simple. Which means it should be innovative and it should be new to the public. It should not be already available information, or already information technology is there and you are going to claim ownership on that particular. No, that is not the case. And second part is non-obvious. Okay, as stated here, a person having ordinary expertise in the technology of your invention should not think that the differentiating factor between your invention and the most relevant technology is very obvious, which nothing but means that the invention that you have created is very non-obvious. So anyone who thinks of creating or making an innovative step should also should also keep that in their mind that it is not an obvious thing, right? So it should be new and non-obvious manner or the process that you create. So there are a few aspects which are non-patentable. Okay, frivolous or contrary to the law, discovery or any scientific principle. Like I stated, so any discovery which is already there in the public domain, which is already been created by 100, or let's say people way before or let's say that has been created by Einstein or such other people, so that is not at all a patentable thing. Okay, that should be novel, like I stated, that should be novel and innovative, known process or machine or apparatus. Correct, as simple as that. So if I today if I invent a mobile, okay, today if I invent a mobile which has a calling facilities, messaging facilities, so on and so forth, but if I have a facility, let's say it should form a stick or whatever that has been created out of just I move that mobile out of my hand and it creates something different, then that is called as an innovative. But if that already machine or that product is already there and I'm using the same thing, you cannot go for a patent aspect. Rearrangement or duplication of known devices, like I said, so it is nothing but duplication. If you have duplicated any work, you will lose patentability. Method of agriculture, very important. Method of agricultural and horticulture, those which are in the horticulture or agricultural business, and if they believe that yes, we have created something different agricultural thing, that is not at all a patentable aspect. So those are some of the important aspect. And one more aspect which is again related to design thing. So when any product, when any process is in the public domain, okay, it is as similar to the design. Any product or process goes into the public domain, you lose the patentability. So you need to make sure that if you have an idea or if you have an any process in mind and you believe that this is going to be an innovative step, if you believe that this is going to be a novel in nature, you should go for a patent. I'll take the registration aspect in the next few slides. I'll brief you what type of applications are there to give you protection. So these are the big no's for patent aspect. Coming to the very interesting and extremely unknown in India, this particular intellectual property is uh, geographical indication, and we called it as a GI. Okay, you have seen these three examples. The moment we see the picture of these three examples, we get to know about origin of the product. Okay, now if I see that pagdi, correct, so the moment I see that pagdi, I get to know that this is a Puneri pagdi. Means Puneri pagdi is the origin of that product. The second aspect is the footwear that we all know that as a Kolhapuri chappal. Correct? Kolhapuri chappal means the origin of that product is Kolhapur. So again, the Darjeeling tea is the first GI that has been granted in India in 2003. So Darjeeling tea is the first registered geographical indication that has been available in India and given to the society. I'll give you an example. Now, this is how that GI is. What GI is? GI is nothing but a indication about the origin of that product. So we all know that Scotland is famous for whiskies, Irish whiskies. So those are again the GI. So it is nothing but a origin. You get to know about origin of that product. So like I stated here, it is used to identify the agricultural, natural, or manufactured goods. Now, I'll give an example. Few months back itself, in Odisha, the community has been granted GI for their chutney, and you will be surprised to know that the chutney is nothing but a chutney of ants. Okay, so these people are very well known for that particular ant chutney that has been given a GI. So this is the importance of the origin of the product. So it is like mentioned here, so produced or processed or prepared in that territory, which should be the criteria, right? So when we talk about Darjeeling tea, it should not happen that I'm going for a Darjeeling tea and some sort of tea has been produced from Kerala or South India and going for a Darjeeling tea. That is not the case. The whole thing has to be from that particular region. Then only we will, I mean, the reason of that particular intellectual property is it is all about the characteristics of that product, right? So when we all know that Alfonso mango, correct? So there are two aspects in Maharashtra, so Raigad and Devgad. So those two regions have two different GIs. The reason of these two different GI is the test, the process of manufacturing that Alfonso, and the climate that has been used for both these two different product is completely different. That is the reason these two different districts have got two different GIs. One is Devgad and other is Rajgad, Raigad, and so on and so forth. So that is the importance of the product that we generally use in all our day-to-day life. So we all know that Solapuri Chadar, correct? Solapuri Chadar, the shawl that we use, also the important. I mean, few months back, we have seen we have dealt a case where uh, we don't know about the mushrooms that are grew in Kashmir. These mushrooms are extremely uh, different in taste as compared to any other part of India. So one of our customers, or let's say my colleague, has appeared with Kashmir, and that particular, I mean, he's fighting for that particular GI. But again, the Kesar is also one of their important product. So it is there are n number of things, and unfortunately, India being a large manufacturer of such product, as of now, only 500 GIs are registered, or GIs are governed or granted in India. Now, particularly when we talk about GI is it is completely different than the other area of intellectual property. Other intellectual property, you can go for individual right ownership. I'm talking about the ownership aspect. But in GI, there has to be the application has to be from the group of agricultural or group of people who represents a society. Those people who form a group, or let's say those are, let's take an example of a farmers. Okay, now those farmers who believe that they are the original creator of that particular product, then they can apply for that particular GI. No one any If I come up and say that I can file an application for GI, that is not the case. Society as a whole, or let's say the region as a whole, can go and file an application for geographical indication. And I mean, we generally recommend people to have the original or authentic product to test their particular aspect. So there we have seen number of cases where we say that this is a Kolhapuri chappal, or we say we have seen many um, mangoes, right, saying that this is Devgad Hapus, Devgad Alfonso. No, those are not the case. When you have a label or tagged on that product, or let's say on that box, that this is a geographical indicated geographical indication product, we definitely recommend or go for such product that will benefit the society as a large. The people that have spent n number of time, they have intellect, use their intellect to grew such product, those will be benefited out of those particular aspect of goods that we procure. So this is the overall structure, or this is the overall briefing about the geographical indications in India. Okay. Now coming to the aspect about registration. So if you remember, the first thing that I have stated is registrations is, or in any form of intellectual property, it is not mandatory. It is unfortunate for us to have that particular aspect, but it is there, right? So when we talk about if the particular registration is not mandatory, it whether does not whether does it mean that you cannot use that particular intellectual property? No, that is not the case. Now when we talk about registration, why registration is important? It is because when you have a registration in place, or when you have a registration, or in a simple word, when a legal document is there with you, it will give you for these rights. So when you have a registration certificate, you get the right to use. the right to exclusively use that particular work. It may be in the form of a work, it may be in the form of a trademark, it may be in the form of a GI, designs, copyright, anything. Okay, it will give you right to use. Second thing is right to sell. Okay, when you have a particular registration in certificate in place, it will have the exclusive right to give or sell that product under your trademark, or let's say under your brand name. It will, and simultaneously you can spot or other, I mean, you can definitely stop the other people from using that particular name, given that you have the registration certificate. So third thing is right to prevent others from exploiting these rights, correct? So when you have a registration certificates in place, you can definitely stop the other people from using the particular brand name or the particular source code that you have created. You can definitely stop the other people from selling that product. So we have seen, I mean, I can definitely name that particular brand, but okay. So there was an instance where Mercedes, we all know that Mercedes is one of their biggest brand in the world. What they have seen is, they have seen a their vehicle. We all know that M class, which is a very unique unique vehicle, and SUV, that is, that falls under SUV criteria. What they have seen is, in Chennai, if I'm not wrong, in Chennai or in Punjab, there was a one garage. Okay, that garage has been using the word Daimler or something, and that person used to manufacture, or let's say if I go there with that particular garage, and if I give him a particular let's say SUV, and I'll ask him to let's say assemble that particular SUV into M class, that person used to do that. When this is where the IP registration comes to picture and importance. When the Daimler, the at that time the Daimler was, I mean, the Mercedes used to name the Daimler came to know about this situation. They approached that person saying that, boss, why, I mean, what is the case? Then when they have a settlement, then that person, that garage has been stopped from manufacturing or reassembling, and he used to assemble that particular logo on their vehicle, which is nothing but, if I have 10 lakh and give that vehicle to the person saying that I need to have an M class, that person will give you M class within 5 lakh. So when I spending 50 lakh or 1 crore for M class, why should I go for such things? So this is the importance. So the reason of this example is, when you have the registration certificates or legal rights over you, you can stop that person from misusing, I mean, I'll quote the word misusing the name or misusing the IP that you have. Other aspect is license. Okay, we every time we heard this particular word license. What is license? License means someone has allowed to use the trademark, or let's say someone has allowed to use the work in terms of source code or whatever is there, for the limited period of time, or let's say for limited jurisdiction of the world. And in the return of that particular license, you will get the royalty. But when you have a license agreement or license in place, that does not mean that the other person gives the ownership on that particular IP that you have created. The IP will always belongs to you, but you are allowing the third party to use that particular IP that you have created in terms of royalty, that we call as a royalty, the money that you will get out of such license agreement. The last part is right to modify or create derivative work. So whenever you have any IP in place, you are the owner of that particular IP. Then anyway, anywhere or anyhow, you are allowed to change the IP that has been already there. And when, if that is the other party's concern, you can definitely stop that person from doing so. But if given that you are the creator, or if you are the originator of that particular, and when you have the registration certificates in place, then you can always modify or create any derivative work out of it. So this is the importance of registrations for any particular IP. Now when we talk about trademarks, okay, there are two aspects of trademark. One is the person who has the trademark registration certificate in place and the other person who have been using the trademark for, let's say, uh, 50 years. Now I'll give an example. Okay. I have been providing the goods and services under the name of Coca-Cola. Okay. And we both of the, I mean, and other party is also providing the goods and services under the name Coca-Cola, under same area of business. The other party has got registration certificate for that particular name or brand Coca-Cola, but they have started using their trademark in 2020. But if I believe that no, and again, I'm the creator of that particular name or work, and I have been using that name since last 50 years, but I don't have the trademark registration in place, still I can stop that person from using that name, even though the person has the trademark registration certificate, because I am the prior user of the work. But like I said, so when you believe that you are the prior user, prior creator, or user which is way prior to the other person, you need to have extremely important documents such as evidence of usage of the trademark. If you don't have usage of the trademark which you claim that you are the prior user, let's say you have been using that particular name for last 50 years, you need to have a very strong documentary evidences to stop the other person from using that particular word. Now in the trademark aspect, we call it as a passing off. Okay. When if I don't have a registration, but I'm uh, stopping any other party from using that name or word, that is called as a passing off. But the if there is availability of a legal documentation in place, that is called as an infringement. So this is how the trademark registration works. So there are other aspect of trademark registration, all these. Okay. Now you take example of trademarks, copyright, patent, design, GI, every each and every registration is now it is an online portal. You don't need to go to any particular registry or visit a particular registry to file an application. That is not at all a case. What we do is we file a trademark application from our own place itself. Now there are cases where what we do is we handle on a daily basis, we file trademark application overseas as well. We have clients in the US, they are sitting in the US and they want to protect their trademark in the US. We sitting from Pune itself, we can file an application. So that is the importance of online portals that are available. So the person who believes that they are the creators or who believe that they created something new, they should not hesitate to file an application. They should right away go and file an application, given that all these are online proceedings. Coming to copyright. Again, the copyright is, like I mentioned, it is an inherent right. Okay. You don't need to have a copyright registration certificate in place. But copyright is when you have a, let's say, legal proceedings, legal issues with your copyright, then you definitely need to have some sort of document in place. At that time, copyright registration will be the most important document that you have to prove that you are the creator of those work. Okay. So that is the importance of the record, or let's say, like I stated in the PPT itself. So when you have a registration certificate in place, you create a document for the ownership of that particular the work that has been there. It definitely permits the copyright owner to record the registration with the Indian customs to help the protection against the importation of infringing copies into India. Now we all know that there are n number of products that are being imported and exported in India and from India. Correct. Now, when you have a copyright protection, or let's say copyright document in place, you can reach out to the customs department saying that, and providing all these documentary evidences, saying that if you find, I mean, instructing the customs department, if you find that if any sort of trademark related product, or let's say if I have a trademark and someone is approaching or importing a trademark with the same product with the name A, or whenever you have a copyrighted material with the literary work that has already been in there, and it is going to be imported, you can ask the customs to stop the importation of that particular product or the particular work that is being getting imported or exported out of India. So that is the importance of the document, having a document in place. Now, one more aspect about the validity of a particular IP. Okay, when we talk about trademarks, trademark is valid for 10 years. It is valid for 10 years from the date of application, and you can renew the trademark n number of times. Let's say if I have a trademark in 2000, I can keep renewing the trademark till 2080, 2090. That is not at all restricted. Okay, so you can keep renewing your trademark for every 10 years. So mota moti, it is nothing but a trademark validity of a trademark is 10 years. Coming to the copyright aspect, copyright is I mean, the validity of the copyright is 60 years from the death of the creator of the work. Means, if I am the or any third person is the creator of the particular work, the ownership of the copyright will be with ownership, or let's say validity of that particular copyright will be 60 years from the death of that particular creator. Okay, now let's take an example of a Van Gogh. Okay, very very famous artist from France or the European countries. The validity now, if I create that particular work, there is no copyrighted or copyrighted material available to him, right? Given that the reason of this is it is already in the public domain, and 60 years has already been elapsed from the death of Van Gogh, and when the 60 years span is done, it is in the public domain. So like I stated, so validity of a copyright is 60 years from the death of the creator. As simple as that. Coming to the patent aspect. Okay, now patent, like I've already mentioned, there are two aspects of the patent. Okay, one is what we call as a provisional application, and the second aspect what we call as a complete specification. When in terms of first thing, which is called as a provisional application, that is an application where if you have anything in mind, okay, now, and it may be in the form of a technology, like I stated, it may be in the form of a technology process, but that is in your mind, and that has not been completed, or it is not in a complete phase yet, and if you believe that this is going to have a very important impact on the society, or let's say if I'm going to have a patent for this, then you should definitely go for a provisional specification, which means you are not I mean, whatever is already you have created out of your mind, you just need to submit with the patent registry, and there is a timeline of, I believe, 12 months where you need to file a complete specification. Now this particular aspect we call as a complete specification is a detailed application of the patent that you have created. Okay, now in this particular aspect, complete specification, you need to have all the aspects about whatever you have created in terms of process, method, each and every aspect should be covered in this particular complete specification. So these are the two important ways of protecting a patent application. Like I stated, it is online application, and you don't need to visit any particular patent registry to file an application. So like I stated, importance of patent is nothing but you have the ownership of your patent. You can allow any other third party to use that patented technology in return of your loyalty or whatever, just to have a monetary benefits out of your patent. It definitely closes down the ownership of a patented technology, right? So there are many people, right? So we personally know many people that they don't have the they created something innovative, but they don't want to have a patent application, and they have just keep that on a open source. And I think we all know Elon Musk, right? So if I mean, there was some invention that he created, he didn't want to have that patented with him. What he did is completely in the different public domain. I- in such cases, you cannot claim ownership on that particular patent or innovation that is created. Now when you need to have a ownership on those particular patent or innovation, you need to have a registration certificate. Coming to the aspect about validity of the patent, it is 20 years. Okay, 20 years from the date of application. It is no non-negotiable aspect. You cannot renew the patent thing. Patent is valid till 20 years from the date of application, I mean irrespective of the validity and so on and so forth. The reason is, in India, let's say patent, once I file an application, it usually, at least now let's assume that if I don't receive any issues or oppositions in terms of patent filed, it takes around 1.5 year to 2 years to get a patent. But you can always say patent pending, patent, so on and so forth. And simultaneously in trademark as well, nowadays it is very faster. If you don't get objections or oppositions for trademark, you get a registration within 6 to 8 months. Similarly, with regard to copyrights, if you don't get any objections or oppositions, you get a copyright protection or let's say registration in 8 to 10 months. So those are the generally considered criteria for granting patents or IP in India. So this is how the uh, patent and all this thing works. Now coming to the design, it is like I stated, it is same. It is an online process where you need to submit the design. Now in design, what you have to do is you need to provide the photographs, that photographs of your product. Okay, you need to scan that photographs and submit along with the form that is already there. And you need to make sure that your photographs or your product does not have names or any description about your product. It will lose the identification, or it will use I mean it will completely lose the novelty over your design. So whenever you apply for a designs application, you need to make sure these few pointers when you apply, that you should always provide the application along with a n number of photographs. So it may include front, back, perspective, top, bottom, everything. So there are few areas, or let's say ways how you need to submit the application for the design. Coming back to the validity of the design, it is 10 years. Okay, design is valid for 10 years, and you can extend for a period of further 5 years. So if I consider overall validity of a design, it is 15 years from the date of application. Like, so just to summarize, trademark is valid for 10 years and you can renew for number of times. Copyright is valid for 60 years from the death of creator of the work. And make sure that it is creator of the work, not owner of the work, right? So there is a difference between creator of the work and owner. Now when we talk about creator means, now let's say if you work for any IT industry or IT company, there is always a agreement between you and company, and that includes a clause such as work made for hire. The moment you create any, let's say, source code, or you create any work, the IP will belong to the company. So this is how the IP protection works. So like I said, at copyright, 60 years from the death of the creator of the work. Patent, it is 20 years. And designs, it is 10 plus 5. So this is how the, and every all the aspects about the IP filing is online. You don't need to go to any particular registry to have the application in place. So this is how it completely works. Now I'll move to the most important aspect about ownership of any such IP. Okay, in India, or not, let's say, see, we being emerging country right now, and we have seen n number of startups emerging, coming with new ideas, new names, so on and so forth. Number of things are happening in India, but people are very, very ignorant. I won't say ignorant, but these people are not knowledgeable about the ownership of their trademark, or let's say ownership of their copyright, or ownership of their patent. When we talk about ownership, there are different aspects about ownership. uh, One way is to have a keeping ownership with an individual. Okay, there is, see, there is no bar or there is no limitation in terms of ownership of any IP. You can keep the ownership with the individual, you can keep the ownership with the entity, or you can keep the ownership with a umbrella company which will allow the other entities to use the name, the whatever the IP that has been created. Okay, so in these three manners you can keep the ownership. Now, when we consider about keeping the ownership of such any IP that is being created, we generally recommend, okay, but it depends on case to case basis. We generally depend or recommend people to have a ownership with the entity itself. The reason is, now let's say, let's take an example. If I'm as an individual, I have filed an application for any copyright or a trademark, and I have owned that particular IP. Now, I being a part of a company and I being the director of that company, the moment I leave the company, the ownership will automatically with me, and company will not have any sort of IP, given that the IP was with me. Correct? So, like I said, so it is always beneficial to have the IP with regard to with regard to the company. Now, on top of that, there are other structures. Generally, in big companies, what happens is, let's say, let's take an example of Tata or something like that. So, what happens is they may have a holding company that is called as a umbrella company, which owns all the IPs and which allow or which license the IP to the other companies. Because when any sort of legal implications happens to the respective entity, the holding company will no longer liable for such sort of IP infringement or IP issues that may happen. So that is the importance of IP ownership. Now, like I stated, so if any ownership is owned or ownership is with a particular individual and some sort of legal implications are there, it will have the impact to the company. And the moment the individual gone, the company will have no IP with regard to that particular application that has been there. So this is the importance about considering the ownership of a IP whenever you go for such things. Okay. Coming to back to, I mean, like I've already stated, ki, protecting valuable assets from insolvency. Like I mentioned, if there is some legal implications with regard to IP, then you definitely have the you will face the issues with regard to your IP. Second aspect is IP held separately from other assets can more easily used as a security, or it can be sold, or it attracts investment through a sophisticated structure. I'll tell you, there we have seen many cases where uh, I mean, the startups, we see many startups working with us, and we have seen aspects where any particular individual owning that particular IP, and that company is looking for an investment, the investors will definitely say and ask the company for which they are investing. They are going to say that, boss, you need to transfer that ownership to the respective company, then only we will invest in that particular company. So this is the importance of keeping the ownership of any IP with the company. So these are some of the advantages that you get when you have an IP with the company. The most important aspect about the treaties that are available. Okay, one extremely important thing about the IPR or protection or jurisdiction of the IPR is it is a jurisdiction specific. Okay, now let's assume that if I have a trademark filed in India, registered in India, but if I believe that someone else is using the same name with the same area of business in the US, I'm not in a position to stop that person from using that trademark, given that it is a my trademark, given that it is registered in India. Which means trademark is a jurisdiction specific. Simultaneously, patent is also jurisdiction specific. Designs is also same, but only in case of copyright, it is not the case. Copyright is something which is like I stated, automated right. So whenever it is created and filed with the trademark registry, you will have the protection in the conventions or member treaties that are available to the world. Now, when we talk about this particular Madrid systems, okay, Madrid system is it is nothing but a treaty that are used or governed for the trademark applications. Now it is nothing but a, let's assume that if I would like to file a trademark application in, let's say, 10 or 20 countries, okay, how do I go? There are two routes. Either you go country specific application, or if you believe that there are 18 to 20 countries where I would like to have a protection, then this particular treaty or this route is the suitable route for going for this particular protection. In this particular aspect, what you need to do is, first you need to have a IP protection in your own country. Okay, now let's assume that if I'm in India, first what I need to do is I need to have a registration in India. The moment I have an application or registration in India, I can go and file only one single application with the trademark registry and select the countries which I would like to have. Let's say if I want to go for 18 or 20 countries, I just need to select 18 or countries the which are available and submit that application with respective fee. That's it. The moment you file that application and you have all the application numbers in place, you are allowed to use your trademark in those respective countries. So this is as simple as that. But it definitely has a fee structure, so there are lot of fees included in the Madrid system. But this is the ideal situation if you like to have a protection for your trademark in more than 10 to 15 or 20 countries. There are around uh, the Madrid protocols include around more than 130 countries, and in India being one of the member country, where you can have a protection. Simultaneously, if someone is sitting in US and they want to have a protection, they can go for a Madrid route, filing an application in the US. So this is how it works. So Madrid route is, to summarize the Madrid system, Madrid route is a route through which you can file a single application for the countries where you would like to have a protection. That's it. But like I said, it is advisable to go for 10 if you are looking for 10 or more countries and you believe that your protection is in India, then this route is suitable. Coming to the second aspect, which is called as a patent cooperation treaty. Okay, that is nothing but a PCT route. Okay, it is as similar to the India. Okay, now but the countries which are member to this particular treaty are more than 150 countries are there. It is as simple as that. If you believe that, and if you want to protect your patent, or if you like to sorry protect your innovation in the respective country, then you need to go through this particular route that is called as a patent cooperation treaty, nothing but a PCT route, where you can reach out to as many as countries where you would like to have the protection after paying some fees. So each country has their own fees in respect of patent application that you need to pay with the respective registry. Only again, this is also a single application, and this route is let's say advisable when you are thinking for going for more than 3 to 4, or let's say more than such countries. Bern convention is nothing but, like I stated, copyright. This is where the copyright aspect comes into picture. Okay, this when India got into this treaty and this particular convention happened, there was a principle that is there. This is called as a automatic protection principle, which means, like I stated, which means you don't need to file a particular application in the respective country for the creation of your work. The reason is the if you are a member country or if you are a member to this Bern Convention and you file an application in India, give an example, if in India, then you have a automatic protection for the other member countries. This is how it simply works. So apart from, I mean, like we need to go for patent or trademark thing, you don't need to go for a Bern Convention. So this is nothing but an automatic protection of your copyright. So I covered this particular aspect about territorial nature of IPR. Like I said, it is territorial, jurisdiction specific. You don't go for overseas protection unless and until you have protection in the respective countries. Now, to summarize and to sum up, and the last slide that I have is extremely important case law that has happened a few months back. You guys are into you definitely knew this particular aspect, artificial intelligence, data, and so on and so forth. Why this particular aspect of IPR is getting extremely important in India is because of this. Okay, there has been a ruling from the Delhi High Court in favor of Mr. Anil Kapoor saying that no other person, okay, just remind this, no other person can use the word AK or the most important word, that jackass, right? So we all know that is a signature word of Mr. Anil Kapoor. The way he used that word, the way he pronounced that particular word, it is not limited to that. It is also going ahead, Anil Kapoor, right? The name Anil Kapoor, the his face, the persona or the style in which he performed, no other party without the consent from him is allowed to use that particular. And again, the most important aspect is voice, correct? This particular bundle of right, it is called as a what we call as a personality rights, right? So personality rights, so this is why, I mean, the reason of this is happening in India, not only in India but abroad, is because of extensive use of AI, right? So we all know with the help of AI you can use some anyone's, we have seen many cases where Mr. Prime Modi Modi's voice has been used. Any number of people's voice is getting used because of just for the sake of monetary benefit. So we all know there was a infamous, I mean, some issue that has happened, Rashmika Mandana, right? So deep fake is one of the dark reality that has been happening in India, correct? So that is the reason. So these are the most important area where you need to think about your own rights. So these people, I mean, this is the one of the example that I gave you about Anil Kapoor, the way he used the jackass, and there was other aspect about jackass as well. The other party were saying, and they were saying that how someone can claim word jackass as their own right, because jackass is very slang word used in Mumbai. But the contention that has been taken is the way he used the word jackass, that is the reason it is allowed to claim exclusive right on those words. So I'm giving an example and why this has been important in this area and this era, particularly 2020, after 2020, all things have happened 180 degrees, right? Because of COVID, everything got into technology. People are started using technology extensively. People started to get to know about what type of IP that they have, their ownership, so on and so forth. So we have seen many other aspect about Ajay Devgan as well, and many other very famous people have started to file and protect such their I mean protection for these IPs. So we all should be aware about the IP that is available to us, right? So I believe you guys are into marketing, you guys are into data protection, and yeah, data protection is one of the boom in India. DPDP Act is one of the most important act that has been implemented in India. We have seen multiple cases where your data is stolen, right? So you need to be very cautious about your own data, your own rights whenever you submit your let's say any creation of your work, you need to make sure that it is going to be uh, properly acknowledged, properly monitored, so on and so forth. So this is how the importance of the trademarks, copyrights, and patents. And not only this, this is all about your day to day working. So on this ground, I mean, conclude my session, and I thank you very, very much to be there with me for